This video sucks. This video is going to suck. Hello, my fam. It is Perez, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. I'm tired. I'm spent. I want to go back to my normal life. I naively thought that by now the middle-aged menace would have withdrawn her subpoena against me because on Monday of this week, she received any communications between me and the Wayfair defendants, ... if they exist. I have never confirmed or denied that I have spoken to any of the Wayfair defendants. But if communications exist, then there's no need to continue with the subpoena against me. And also, as I've said before, if communications between me and the Wayfair defendants exists, and it's some smoking gun or would hurt their case, I would think the Wayfair defendants and Steve Sarowitz, a billionaire, would have maybe figured out a way for me to have a lawyer and paid for it. But no, they didn't. And I'm still handling all of this by myself. But hopefully that will change soon. I have had some conversations and I'm cautiously optimistic that I might be able to figure out some legal help this week. But until then, and I hope to make an announcement soon if God blesses me with that. Until then, it's me and her team of very expensive lawyers. All right. As I previously shared with you all, last Friday, I filed a motion in Nevada asking a lot. I am fighting the subpoena superstar here in Las Vegas, the correct venue to litigate issues with her overly broad, duplicative, unduly burdensome, and I think legally unsound subpoena that is asking me to unmask my sources and give her my unpublished journalistic material, all of which is privileged and protected by both state and federal law. Basically, I wanted and I need the judge to explain in writing his decisions last week at the hearing that we had in person on September the 2nd. At that hearing, the judge said that he would not be applying Nevada law in Nevada, which is not only infuriating, but also does not make sense whatsoever. Because repeatedly, Cherokee Khaleesi argued that California law should be applied in New York, and Judge Lyman applied California law in New York in his federal court. Even as recently as this week, when seeking damages against Justin Baldoni and trying to recoup her attorney's fees, she cited California law. So I think it is only fair, equal, and just that Nevada law apply here in Nevada. But the judge disagreed, and I just want to know why. He didn't explain why to me. So in my motion from last week, on Friday, I asked him to explain why. And I'm dumb. I'm also not a lawyer. I need to know why this judge needs to know the names of my sources, the very same thing that I'm trying to protect. The very same thing that is privileged. I even told the judge in chambers, yo, I didn't say yo, but I said, Your Honor, I'll give you all the communications redacted, meaning you can see what was said, just not the names of my sources. That didn't fly with him. And he could not or did not explain to me why he needs to know the names. So in my motion from Friday, I said, please also explain to me in writing why you need that. And I said, let's put a pin on it. Let's pause things until I get this needed clarification that I reserve my objections to, because I'm probably going to be appealing this if the motion to quash that I filed is not granted in full. And now Butthole Blake has responded to that motion of mine. I am reading it live for the first time. God, so over it. Let's see what they have to say. Response to third-party Perez Hilton's motion for clarification. Respondent and cross-movement Blake Lively respectfully files this response to the motion for clarification and for a protective protocol governing any in-camera submission, assertion of reporter's privilege, request for written explanation regarding applicable law, and request for stay pending resolution, filed by non-party Mario Armando Lavandeira Jr. Ms. Lively takes no position on Mr. Hilton's request that the court issue a written opinion memorializing its orders at the September 2nd, 2025 hearing, but notes that oral orders are entitled to the same force and effect as an order reduced to writing. Great. Explain it to me. I think I deserve that. And so does the public. It should be stated for everyone the reasoning for these decisions, these rulings. Ms. Lively files this response in opposition to Mr. Hilton's following three requests. 1. Permission to withhold from the court, they put in bold and italics, permission to withhold from the court the identity of the individuals with whom he is seeking to withhold communications. 2, a stay of his obligation to submit cost estimates from e-discovery vendors until after resolution of the motion. Pause. I did that anyways. Even though I was looking for a pause, I went ahead and gave the judge what he asked me to do. He wanted me to get 3 estimates, 3 proposals from forensic data retrieval experts who would potentially take my digital world, all of the places that I have my communications and information stored, and extract everything that the subpoena is asking for. So I did that on Monday as requested. But their response today continues, saying 3, they're objecting to this as well, an order holding that the court will not disclose any material submitted ex parte to Ms. Lively, meaning without her there. If I had another in-camera review with just me and the judge. For the reasons discussed below, the court should reject all 3 remedies as devoid of legal support. Jesus Christ. Relevant procedural history. The court held a hearing on August 28, 2025, on Mr. Hilton's motion to quash the subpoena Ms. Lively served on him pursuant to Rule 45 of the Federal Rules of Civil Procedure, and Ms. Lively's cross-motion to transfer or for an order compelling Mr. Hilton's compliance. The court deferred a ruling on the motion to quash and cross motion during the August 28th hearing, pending a determination from the district judge overseeing the underlying litigation as to whether the Southern District of New York has jurisdiction over Mr. Hilton. After that court found it lacked jurisdiction to adjudicate the subpoena, this court denied the transfer requested in Miss Lively's cross motion and ordered the parties to appear for a motion hearing on September 2nd, 2025. The court also ordered Mr. Hilton to come prepared with a list of materials covered by the subpoena that can be presented to the court for ex parte in-camera review, and which describes the type, format, and volume of this information. I did that. The court also ordered the parties to provide supplemental briefing regarding whether and how privileges under the federal common law, including but not limited to the qualified reporter privilege, apply to this information by Tuesday, the 2nd of September at 9 a.m. The afternoon of August 29th, 2025, Mr. Hilton submitted his supplemental brief this is not true! Confirming his view that the federal qualified reporter's privilege applies and that Nevada's journalist privilege is not binding, but provides additional persuasive authority. Pause. I repeatedly stated then and before and after and in person in court that Nevada law should apply. The Nevada Shield Law, which offers absolute protection, not qualified, should be applied. And this ridiculousness should be over already. Jesus. On September 2nd, 2025, Miss Lively filed a supplemental brief as ordered by the court, explaining why federal common law as opposed to Nevada law applies to the question of privileges because the underlying litigation includes a claim pursuant to federal law. At the beginning of the hearing on September 2nd, 2025, the court entered an oral order, September 2nd order, holding that the federal common law applied to the question of whether Mr. Hilton is entitled to assert a reporter's privilege, and if so, whether it is overcome due to its qualified nature. The court explained that the federal common law applies pursuant to Rule 501 of the Federal Rules of Evidence because the underlying litigation includes a claim rooted in federal law. There are two interesting footnotes here. One says Mr. Hilton claims to maintain all objections, notwithstanding that he agreed to the application of the federal common law. No, I did not. I did not. And, oh God, footnote 3 says, Miss Lively disagrees with Mr. Hilton's claim that the court did not offer an explanation for his holding. The court did not offer an explanation. The court closed the courtroom to hold an ex parte conversation with Mr. Hilton during the hearing regarding the privilege log he prepared. Miss Lively reserved rights relating to the ex parte conversation, including to the withholding of any privilege log provided to the court ex parte on that day or in the future. After the ex parte conversation, the court ordered Mr. Hilton to submit to the court by Monday, September 8th, 2025, 3 estimates from e-discovery vendors for the cost of engaging in a forensic collection of all the repositories of information likely to contain responsive information. The court also recommended that counsel for Miss Lively provide Mr. Hilton with a list of suggested attributes of a credible e-discovery vendor, which they provided by email on September 4th, 2025, along with providing names of specific reputable e-discovery vendors. Like I'm going to use their vendors or whom they recommend? No. The court also suggested that counsel for Miss Lively provide search terms to Mr. Hilton, which are attached hereto under seal. Then they get into the nitty-gritty. The court should reject Mr. Hilton's request to permit him to file a coded privilege log whereby he withholds the identities of his sources from the court. Mr. Hilton does not cite any authority in support of his request to deprive the court and only the court of this information, including his assertion that courts routinely accept coded privilege logs that omit names. Nor is Miss Lively aware of any authority that empowers a third-party litigant to redact information submitted to a court in an ex parte and in-camera capacity. Can we just fast track this? Let's just fast track this so I can appeal it. And then let's fast track the appeal. I just want to be done with this. But I'm going to keep on. I'm not going to stop. I'm going to stay fighting. I'm tired, but I have an indomitable spirit. You can kick me. You can break me, but you can't destroy me. I will put my pieces back together again. God. They continue. To the contrary, district courts act within their rights to require the unredacted submission of material for such review. I don't trust a thing they say because they've lied and misrepresented the truth over and over and over again. It is not clear how the court could assess whether the privilege is overcome, including, for example, the materiality of the information or the availability from other sources, if Mr. Hilton does not provide details about from whom he received the information. For example, whether Mr. Hilton communicated with one of the defendants in the underlying litigation or a defendant's agent, including, for example, Brian Friedman, is essential information when considering whether Miss Lively has demonstrated the 3 factors that courts consider when piercing the privilege. Mr. Hilton also provides no legal support for his invented 3-step staged plan of ex parte review. And such a process would add additionally unnecessary layers of delay and review. Maybe ChatGPT had me going in the wrong direction here. Dad, I don't know, it sounded sensible to me. First the court gets my redacted names or source names, blah, blah, blah. I'm doing my best here, people. I'm not a lawyer. I'm doing my best going up against Goliath. And I shouldn't have had to spend, by now, at least $75,000 to do what's right and protect my sources. The justice system in this country is so backwards so much of the time. There's a little footnote here after that about the invented process. It says, Mr. Hilton appears able and willing to submit the content of his communications to the court and takes issue solely with the disclosure of names. Yeah. Yes. That's what's important. Protecting my sources. If Mr. Hilton is able and does not oppose the submission of a sample of underlying communications, Miss Lively submits that doing so would facilitate the court's review and is in keeping with how courts often handle in-camera review. I told that to the judge in camera. He didn't want that. I literally said, Your Honor, wouldn't it be more helpful for you to know what was actually said in these communications? Like, couldn't you determine privilege easier if you know what was frickin' said? Like, it doesn't matter who told me. I'm claiming it's all privileged. They continue. Mr. Hilton also asks this court to stay or hold in abeyance any further obligations until the court resolves the motion. Mr. Hilton does not, because he cannot, provide any factual or legal support for delaying the process established by the court. The September 2nd order does not require the disclosure of any of Mr. Hilton's sources, and there is no reason why the process laid out by the court cannot proceed apace while the motion is under review. They knew, because they got the filing, that I already gave the judge what he asked of me even after I filed this motion. Not very good lawyering. They should have updated this filing of theirs. Yeah. Boys Schiller here in Las Vegas. Richard Pucker. I'm losing my mind. I'm going bananas, and I feel like my poor little mind is being devoured by piranhas, 'cause I'm going bananas. Finally, the court should also reject Mr. Hilton's blanket demand that the court prohibit disclosure of any in-camera submission to Miss Lively. Mr. Hilton ignores that ex parte in-camera review is extraordinary and should be limited to only instances where it is absolutely necessary. To the extent that any of the materials submitted to the court ex parte are not in and of themselves privileged, there is no legal basis to deny Miss Lively access to those materials. Respectfully submitted. Okay. I think I have to respond to this. Do I have to respond to their response? I haven't asked my dad yet. I feel like I should respond because they're misrepresenting a lot here. Dios mío. Por favor, ayúdame. Okay, I have nothing else to say. I said this video was going to suck. This video sucks. This video sucks. Thank you for watching. Thank you for watching and supporting and being there for me. I don't know. Whatever. I will be answering anything in the comments. I'll see you in the comments.